Hi, I'm Hisnara, the editor of CheekyLittleCareers.com. Thank you for joining me. I'm delighted to say that for this short video interview, I've been joined by Richard East, who is the senior partner at a very well-known US law firm called Quinn. We'll talk a bit more about Quinn in a moment, but let me get Richard to start by introducing himself and to give us an insight into how he broke into law, because Richard has spoken in the past about how he was essentially a bit of a dropout at school and entered the profession slightly later. Hi, Richard, how are you?
I'm very well, thanks. Very nice to meet you, and thank you for giving me the opportunity to appear on this. So yes, high school dropouts. Yeah, it's correct. I left school in my first year A levels, rather disenchanted with education at the time, wanting to get a job and earn a living, but tried to do that for several years, ended up doing some rather not very exciting jobs, and then eventually after about 3 years concluded that I probably needed to go back to education. And then I started on an Access course which was attached or affiliated with Warwick University, and did that for a year, and that was the year in which I really got my first exposure to the law, because one of the topics in the Access course was law, and that was the first time I'd ever had any exposure to it. None of my family had ever been in the law. Really, my parents were the first parents to have gone to university. And it really interested me in a way that I'd never been interested in anything previously. And so as a consequence of that, I applied to several universities to try and study law. I obviously applied to Warwick University, but I also, as a sort of fantasy pick on UCA, picked the LSE, not expecting to ever get even an interview at the LSE, but for some reason I did. I got an interview, which I didn't think went very well. It's another lesson. And then they invited me to do an exam, a sort of entrance exam for the LSE, which I did. And again, didn't think I'd done very well, but somehow managed to get into the LSE. And I think as a consequence of being in the working world for a few years, I really valued the opportunity I was given, and I worked incredibly hard on my degree and managed to come out with a first-class degree. So,
wow,
and that obviously opened up doors and opportunities which I wouldn't have got but for that opportunity. So yeah, so that was my sort of rather unconventional introduction to the law. And then on the back of that degree, I got offers from a couple of major firms to be on their training, the training program. One was Slaughter and May, one was Baker McKenzie. In the end, I think I chose Baker McKenzie because I thought they're slightly more relaxed. Wasn't coming from an Oxbridge background, which even at that time was quite unusual to apply to somewhere like Slaughter's. I think, in fact, one of the partners even said to me that I was the first non-Oxbridge offer they ever made. And that kind of put me off. And so I went to Baker's, where the trainees were all kind of people of varying different ages and backgrounds, and I felt much more comfortable within that kind of environment. It was a smaller training group, and Baker McKenzie was a fabulous firm to train at and then qualify.
That's a really significant achievement. So, really fascinating. At any point, did you think you're aiming too high? Did you feel like giving up?
Yes. I mean, people talk about imposter syndrome now. I mean, yeah, I think almost at every point, I didn't feel as though I was, good enough. As I say, I was coming from left field, or and yeah, I mean, it's very difficult going into, and I appreciate, when I recruit and I deal with people coming from different backgrounds, I appreciate how difficult it can be sometimes to get into the working world and feel as though you're part of that and that you deserve to be part of that. So, but I had some very good mentors at Baker McKenzie, and then at Cadwallader, which I think was one of the foremost experiences that I had in terms of forming me as a lawyer, but also as to an extent as an entrepreneur in the context of being a lawyer, because the lawyers that I met there were of a sort of fantastic quality, and they've all gone on to different firms now and all been successful. But Cadwallader, yeah, was a sort of an experience that really sort of forged my view of the world and gave me a lot of confidence to take the steps that I then subsequently took. I think the other thing as well is that I've always been willing to take on sort of acceptable levels of risk, and I think that has also helped me in my career. Whereas I obviously haven't stayed at one firm for 20 years or 25 years. I've moved around when I've seen that there is opportunities that I can take, and not always opportunities that have any sort of guaranteed outcome. So, I mean, for example, the move to Quinn Emanuel in sort of 2008 was not a move that had any guarantees attached to it. I was the first partner to join, but it was very exciting, and I could see the firm being successful in London. Or if it wasn't, I knew it wouldn't not be successful for want of effort. So, and at the end of the day, I didn't really see the downside in giving it a go. So anyway, sorry, I'm sort of rambling a bit.
No, that's absolutely fine. It's really, really interesting to hear. You have moved around a bit. You mentioned that in your response just there. Lawyers are notorious for staying put, thinking, lots of royalty will guarantee that sort of coveted prize of partnership longer term. It sounds to me that moving between firms has really made you the lawyer.
Yeah, I think so. I mean, so I started off at Baker McKenzie.
Yeah.
And I qualified there. I qualified it actually into their corporate group, surprisingly. But I knew then that I wanted to do something that was more sort of contentious. Actually, I was very interested at the time of doing insolvency restructuring work, and Baker's really didn't have anyone that really specialized in that area at that time. So I knew I had to move somewhere to achieve that. And then at the time, Cadwallader had opened an office, and they'd hired Andrew Wilkinson, who was a restructuring insolvency partner from CC.
Very well at the time, I remember him very well.
Yeah, and they just hired him. The recruiter called me up and said, look, there's this new office opening, Cadwallader, hired Andrew. They then subsequently also hired James Room. I've got another funny story about James Room, who is obviously went on to head up Bingham & McCutcheon, and then has obviously now in Aiken. Yeah, and also I met Philip Hertz, who's currently the head of CC restructuring bankruptcy, and he was pretty much a mentor to me as soon as I arrived there. And also Lyndon Norley, who then went on to found the Kirkland restructuring practice that I then subsequently joined. So it was full of all these fantastic people. And the first person I met was Russell Jacobs, who was a Millbank, who's now at Millbank, a tax partner, and he was a really nice guy. So yeah, so I made that leap, and everyone at the time said, you don't want to join US firms, they're sweatshops, all that stuff was around at that time as well. But I was really excited by the opportunity and excited by the people that they'd hired. So I made the leap, and it was challenging. I was there for nearly, for 4.5 years, nearly 5 years, and it was a very challenging environment, both in terms of the people that I was working for, who were incredibly successful but also very demanding, and that sort of had to raise my game very considerably. But also the office was sort of often the people there were fluctuating quite regularly, and so there was also a feeling of you didn't quite know whether the firm was going to be there in 6 months' time. So it was quite a challenging environment. But as I say, it showed me what it took to be a successful partner at the very top of the profession, both in terms of how you do the work, how you present the work. We were working at the time for very demanding clients. Some of them were kind of the more demanding sort of hedge funds, in restructuring situations, who demand absolute, commitment to what you do. It also showed me how you start up a law firm, how you start a law firm, how you go out, how you present, how you win work. Because when I joined, there were only 7 lawyers in the office, and it was literally a startup. So I saw that as an associate on the inside, and it was a fascinating experience. And to work alongside people like Andrew and James was a very, sometimes challenging but also rewarding experience at the same time. And the funny story I have about James Root is that I'd never met him at all. I knew he was joining the firm, and I think I was on my first or my second day in the office, and Andrew Wilkinson walked in and said, "Hi, I'm Andrew. Nice to meet you. Hi, I'm Richard. Blah blah blah. Do you fancy doing some work in Bangkok?" And I said, "Yeah, that sounds great." And I said, "When?" He said, "Well, today." There's a flight that leaves around 6:30. You've just got time to get home, pack a bag, and get on the plane. So that's what I did. And I met James Room for the first time in the banyan tree in Bangkok, where we spent, I have to be honest, quite a miserable 2 weeks locked up in a hotel trying to do a restructuring of a local Thai company. So that was my sort of introduction to the firm, and my introduction to James Room. So anyway, sorry, again, I'm sort of blathering on a bit, but then I felt at the time Cadwallader, I'd done sort of 4.5 years of being there, and again another opportunity came up to move to Kirkland, because one of the partners at the firm had moved there and had founded for the first time again a sort of English orientated restructuring practice. And again, it looked like another great opportunity to be in on the ground of something and help. But at this point, a slightly senior level, I was going in, I think I was something like 6 years qualified, 6 or 7 years qualified, together with somebody that I knew really well, who was heading up the development of the practice. So very attractive to me again. I was at that point obviously thinking about partnership. Was I going to make it at Cadwallader? Could Kirkland provide a different opportunity? And I decided, I decided that actually being on the inside of something that was very, again, new, probably presented the best opportunity at that time for me to make partner. So again, I made the leap and had a very successful time at Kirkland. Did make partner there in 2004, if I remember. And then I ended up doing what for me was a perfect mix of work. I did some contentious insolvency work, arbitration work, which I've never really had any exposure to previously, and then high court litigation as well. So, and I had, there was no other, at the time I joined, no other litigation partner there. So I was very much at the front end of all the kind of litigious work that Kirkland threw out. So again, a great opportunity.
What attracted you to restructuring work in the first place?
Initially, it was the fact that restructuring sort of throws up so many kind of interesting legal issues. I mean, it crystallizes so many, issues that arise under contracts. It involves common law, sort of property, equity. I mean, everything that you could think that was interesting in the law, insolvency raises in one form or another. Sure. And it's also can be very dynamic and very fast paced. So it was the academic attraction I had to the subject matter, plus the kind of fast pace. And certainly in the firms I was working in, Cadwallader and then Kirkland, I was very much at the front end. I mean, I was involved when I was at Cadwallader on a very large piece of commercial litigation involving the Noboa family, where I was working with Lord Grabiner and Ian Glick and Ken McLean with the barrister team. And I was essentially the instructing lawyer. I was a 3-year, 4-year qualified associate. So the kind of, the philosophy of US firms is much more, if you've got the talent and you're prepared to do it, you're given much more free rein to get on with the work. So yeah, and it was the same at Kirkland. I was at the front end of most of the things that I was doing, a lot of exposure, a lot of responsibility. So so yeah, and then obviously the Quinn Emanuel opportunity came up, and again it was another opportunity to be at the front end of a evolution of a new practice, but this time I was a partner and the founding partner. So really, given my career of of starting in US firms and seeing them evolve and develop from the beginning, this was an opportunity to be right at the front end and use all of the things that I'd learned over the years and seen and observed for myself in the way that that you can build up a practice. And I was also determined and also knew, and I think this is a really important thing, that when you work in US firms, you can't expect the mothership to simply deliver work for you. It just doesn't work like that. You have to earn your own reputation in your own marketplace. You have to find your own work.
Yeah.
You can't expect, just because Quinn Emanuel, Kirkland or Cadwallader act for client X or Y in the US, that you can just sort of wander into their office and expect to be given work. You have to earn that. You have to. So I spent many weeks, months, years going around to see people, trying to convince clients to give us a chance in London, and slowly those efforts, and obviously together with other people who were at the firm. Sue Provisa QC joined me after a few months when I started at Quinn Emanuel, and she and I worked hand in glove, worked very closely together in wandering around the streets of London and seeing as many people as we could to pitch.
Come on to Quinn in a moment, because I'm fascinated to hear sort of how it's changed in the time that you were there. But a question I had: every move you made seemed quite risky. You were joining firms that hadn't established themselves properly in London.
Yeah.
There was, I remember writing about some of these firms as a journalist, and there was, partners moving backwards and forwards. You were concerned about whether a firm was going to still be standing, etc.
Yeah.
How did you manage that risk? Because I think that's what makes so many people feel very nervous about moving on, even when they are utterly miserable in their current life.
Well, I think I reasoned with myself, certainly the Quinn Emanuel move. I reasoned with myself that what was the downside? What was the worst case? The worst case is I joined, I gave it a go, I tried my best, and it just didn't work out because there wasn't really the opportunity that I thought there was, or at least there wasn't any demand for the kind of firm that Quinn Emanuel was. And I took the view that I'd been a partner at Kirkland, I'd got a relatively good track record in terms of the type of work I'd been doing and how hard I'd worked. And what was the worst that can happen is I'd do it for 2 years, conclude that it's not worked, and then try and get another job with another firm. I mean, that was the worst. I have to say, and this is a bit of sort of personal background, is that just prior to joining Quinn Emanuel, I'd lost my first wife to cancer. And so I'd been through quite a difficult period. And ironically, maybe not ironically, that personal experience of seeing someone, suffer from the illness and pass away relatively young, I think made me even more willing to take on risk, because you really do think, well, what is the worst that can happen to me by doing something like this? And I also knew that actually, if it worked, it would be the best career move I ever made, and as it's turned out, it has been. So I guess that maybe that kind of personal experience in the background, and also the fact that my previous moves to other firms had been relatively successful in the sense that I'd found the work that I wanted to do. I'd experienced being, in a firm that was growing and trying to establish a reputation. I made partner at Kirkland, so that wasn't a bad move either. Worked with some fantastic people who are still in the market now, and I still regularly work with in various different situations. So maybe that was it. I just was not risk adverse. Had an entrepreneurial streak, so I was attracted to those sort of opportunities, and it's worked out pretty good in the end. So
What I've learned from this is that you have proactively managed your career. You've taken chances, you've explored opportunities, even if it's just to make an inquiry,
Yeah,
and rather than just sleepwalking into a career cul-de-sac, which is what I think a lot of associates do,
yeah,
because the alternative is to take a risk potentially.
yeah,
So I think you're a great example of someone who is able to carve your own definition of success through experimenting, taking a chance, a risk here and there,
yeah,
rather than waiting for something just to happen, you know, automatically in one single firm. And I don't
yeah,
think necessarily. And it also sounds to me that by moving around, you've
yeah,
had exposure to the working styles of so many, different lawyers and
yeah,
partners who
yeah,
are real industry heavyweights of their time.
yeah, yeah, yeah. No, absolutely. I've worked with some of the, in terms of the restructuring market, if you will, I've worked with some of the best,
Yeah.
restructuring lawyers there's ever been in the last, 2 decades. So yeah, and I've taken a little bit of, I think, of all of those people and tried to reflect that in, how I operate in Quinn Emanuel and the kind of environment that we create and the kind of lawyers that we try and attract as well. So yeah, so I've benefited a lot from seeing lots of different partners operate in different ways, some good, some bad.
But it's all, interesting sort of learning
Yeah,
experiences.
I think you have to take risk. At the end of the day, law firms are commercial enterprises. It doesn't matter how big they are. At the end of the day, their success is built on, a commercial success, which is doing the work, delivering the product, getting paid. If you can do that at any firm, you'll be successful. But there's nothing quite like throwing yourself into a situation where you've got to do that to survive, because it really does force you to take on board, all of the dynamics and the commercial necessities of life. When we started Quinn Emanuel, we literally started with 0 clients. There's only one way. There's only one way you go from that point.
Okay, let's talk about Quinn then.
Yeah.
Because we're going to run out of time otherwise.
Right.
Now, I remember Quinn entering the London market as a journalist. It was all on the back of concerns that every well-established city law firm was never going to litigate against the banks. There were
Yeah.
conflicts. And,
Yeah.
you arrive with a huge fanfare. We're going to sue banks. We're not conflicted, etc.
Yeah.
I know in previous conversations you've said that Quinn has now diversified in terms of the work it does, and it's quite
Yeah.
different. Can you give us a quick plotted history of Quinn from the day you arrived to where you are now?
Right. Okay. Quick potted history. So you're absolutely right. That was when we first arrived, that was the sort of niche that we identified that it would set us apart from, all the other UK and US firms. And as you know, at the time, probably the banks took out, they were absolutely, central to most of the big firms' kind of business plans. The banks were so integral to pretty much everything that went on in the city and so across the banks, they probably took out, 4/5 of the big firms in terms of conflicts. So we identified that as a niche, that no one was really there were the odd firm that was prepared to take on the banks here and there, but there was no firm that was going out into the market and saying, this is what we want to do. This is actually what we want to do. So if you want to sue HSBC, Barclays, whoever it is, we can do it and we're free of conflicts. So that was a big sort of sea change, and that was our niche, and that was very successful. We were also fortunate, timing can be a big, can have a big role in these things sometimes, is that we launched in April 2008, before Lehman.
Yeah.
So we launched at just the right time, and then obviously there followed a lot of, bank litigation falling out the credit crisis and Lehman and other things. But yes, since that, we also knew that work wouldn't last forever. Limitation periods, at some point that work will pass. So consciously then we decided to try and broaden out the practice into other areas. And over the years, we've done that very effectively. We've hired some top rated, arbitration lawyers. We've built a practice in contentious tax, competition, other areas, white collar, we do a fair amount of white collar. We've hired some of the top commercial disputes lawyers, construction arbitration. So we pretty much now have someone who specializes in pretty much any area that you have kind of major disputes. The one missing link at this point is patent. And I've been looking for the right person in patent litigation almost since the first week I started, nearly 14 years ago. And we're still looking. And I'm still hopeful that one day we will fill that hole. Interestingly, though, we are actually doing patent disputes, despite the fact that we haven't got anyone who is really, would be regarded as a patent specialist. We work a lot. We have a very, very, patent litigation in Quinn is a very substantial part of what we do. We've got a very strong practice in Germany and a phenomenally strong practice in the US. So we do have the odd matter that comes up in London, which we act on. And so, but it would be really great to find, one or two, patent specialists. It is an area, though, where there are lots of conflicts as well. So you kind of have to choose your sides in patent litigation, both in pharma and tech.
Yeah.
So we've had quite a few situations where we've had very I've almost managed to hire someone, but there's been a conflict or something that's come up which we can't get round. So, but I'm still trying, and we will get there, I'm sure.
Yeah.
So, but yes, so the practice now is very broad, 26 partners, 70 associates, so around 100 fee earners. So as I say, there are not many areas where big disputes that come up that we're not, in somewhere.
Okay.
Anyway, so sorry, that's.
Can we talk about culture?
Yeah, sure.
Now, whenever I talk to junior lawyers, by the way, any students listening to this, it's worth noting that Quinn doesn't have a training contract program.
No.
Really, we're speaking to sort of NQs and upwards.
Yeah.
But useful to watch anyway, because it gives you an insight.
Yeah. Although we do have interns, just so this is a slightly.
Thank you for clarifying. Okay.
Yeah. So we have taken on a number of people who are qualified in other jurisdictions. So for example, I'll just give you an example of one specific example. So India, we have taken on some Indian qualified lawyers who have gone to do the BCL at Oxford or have done Harvard LLM. Yeah. And we've taken them on as interns and given them a 12-month contract. And then those people we've then converted into associates who can convert their qualification into an English qualification that we've taken on. So it's not really a training contract, but it's not sort of just laterally hiring out of other firms. And actually that's been very, very successful path in terms of hiring, lawyers from other jurisdictions. So sorry, so I just wanted to qualify that. But yeah, you're right.
No, absolutely. Yeah. Thank you for clarifying that. That's really interesting and useful to know. So let's talk about culture. So junior lawyers I speak to, and I do that on a pretty regular basis. Quinn has it's Marmite. Some junior lawyers are desperate to work for your firm because it's like the destination of choice for ambitious, lawyers. Others are like, no. It's going to be, it's got a bad reputation for being a bit of a sweatshop, Rottweilers, etc., etc. Can you set the record straight? What is it like to work at Quinn?
I will try. It's like one of those problems, though, isn't it? Unless you're inside, you don't really, you can't really tell. But let me try and sort of address things. So I think we've been really successful in the London marketplace of creating a very strong brand for the practice as you say, aggressive, American litigators. There's no doubt about that. People kind of have got that message now. But I think the problem is with that brand is that it's a professional brand, right? Is that it's directed towards clients. And it doesn't reflect, and I think a lot of people think it does reflect the internal culture of the firm. In other words, we're all really aggressive and horrible to each other. And that's the kind of the culture I think a lot of people have, think that we have. I mean, I've seen, sometimes you see comments and Roll on Friday, what a horrible, toxic place we are. It could not be further from the truth. And I suppose the only evidence, objective evidence that I can present to that is that we've been going now for nearly 14 years. And in comparison, I think, to a lot of other US firms, you just do not see the throughput of associates and partners. And so that's the only objective evidence I can present to someone outside the firm. But the way, at least I see the culture, it is a hard-working culture. And some of our associates, do work very, very hard. But that's a function of the fact that there's a lot of work going on. And I don't think that makes us any different from Skadden, White and Case, Kirkland, Allen and Overy, Linklaters. If you're at the top of the profession doing all the big high-profile cases that we are doing in the marketplace, then it's going to generate a lot of work, and it means that our associates and our partners are busy. There's no escaping that. But it's not a culture where we insist on people being in the office, with the sort of jacket on the back of the chair. We have lots of people with young families who manage to balance family life and work life. We don't have a lot of how do I put it? We don't insist on a lot of internal meetings about this, that, and the other. It's very focused on the work that we do. So people really just do the cases and the work they've got on and nothing else. We're not demanding much else of people. And coming out of the pandemic, we're going to sort of maintain a balance of saying to people, we want you to spend some time in the office, but we're happy for you to work from home. We don't care what you wear. It is actually quite informal. There's not pronounced hierarchies. Anyone can walk into my room. Anyone can walk into any partner's room and have a chat. It's very informal. And I think it's a high performing culture, but it's also quite a pleasant culture. We have lots of diversity. We have lots of people from different jurisdictions. We've got a good mix of women and men, not at the partner level yet, but that will change because we've got some very talented women associates and of counsel that are coming through, and we made up 2 or 3 women in the last few years, but we need to get better at that level. But in terms of the associate body, there's a very good mix of women and men, and a mix of different cultures. I mentioned the Indian internship. There's people from New Zealand, Australia, East European countries. It's a very kind of eclectic bunch of associates, which I think makes it a very interesting place to work. It is a challenging place to work because of the type of work we do, and because in the firm at the moment we don't really have groups of associates attached to any particular type of practice area. The associates essentially available to do any of the disputes that we're doing in different areas, which means that you can, one day be working on a case with me in an insolvency scenario. The next day you might be working with Ted Greeno on a commercial litigation or an arbitration. The next day you might be helping Liesl on contentious tax. I mean, that kind of, that's open to all our associates to do that kind of mix of work, but which makes it challenging.
Yeah.
But I think our associates, I'm personally, I'm biased, but I don't think there's a better place in London to do litigation. And even the people that have left us who didn't, for one reason or other, make partner of a firm, have all gone on to have very successful careers at other firms and have made partner in other firms, because they are very aware of the kind of the economic, the kind of the how to generate work, what you need to do to get in front of clients, and they're exposed to that in our place that I think they are not exposed in other firms. And they work very hard, and they know, there are many of our associates who are quite junior, say 3 or 4 years, have done multiple high court trials. And I think that kind of experience is difficult to get as well in other bigger firms. So the kind of experience you get in our place is also unmatched, which I think stands you in very good stead to make partner, or to make, whether that's at Quinn Emanuel or whether it's at a different firm.
So does that mean you can promise junior lawyers who join your firm proper work rather than spending 2 years doing doc review, which is
Absolutely. I mean, our associates, as a rule, generally don't do any doc review because we have a body of people in the firm that we refer to as legal assistants, who are kind of people who provide low-level legal assistance. They do a lot of the doc review. I suppose they do the kind of work that you would expect to some extent a first or maybe a second seat trainee do in a big firm, filing stuff, at the court. And then if we have really big document review exercises, then we tend to recruit in temporary lawyers to do those types of exercises. So then our associates often will oversee those types of exercises and may do a second stage review of stuff that's been reviewed. But no, we don't really see our associates as doing that sort of work. So they will,
is such an important part of developing as a litigator, because I have heard horror stories of some juniors, NQs being stuck in a data room doing doc review, not having any client contact.
Right. Well, there's two things. Clients won't pay. They won't pay £400 an hour for people to do that. So there's two things: is that you can't say, oh, we've got this, team of associates charging £300, £400, £500 an hour to do your document review. The clients won't live with that. So that you can't do that from that. In any event, we'd much rather our associates actually doing the real substantive work. And as I say, our associates tend to get a lot more exposure to the work, and are really involved in the strategy of the case and in producing the material, analysis or the evidence or whatever it is, but they're working on the actual issues that arise in the case. I can't think of any of our associates that would have spent years doing a document review. It's just not effective.
I'm afraid we're out of time.
Right.
So any closing remarks? It sounds to me that Quinn is a very fascinating place to work, and thank you for dispelling some of the myths that I'm sure.
Well, I hope I have dispelled some myths. I'm sure some of the myths will continue, notwithstanding this. But as I say, I think if anyone wants, one of the things we do in terms of recruitment of associates, if they interview us, is that we always offer for those associates to meet a group of the associates in the firm, so they can actually meet the people who are experiencing Quinn Emanuel at that level, and can see the kind of people that we hire and are doing the work, and they can ask obviously for the real truth from those people, as opposed to hearing it from the partners.
Fantastic. Well, look, thank you very much, and wishing you all the best for the rest of 2022.
Thank you for giving me this opportunity.
You're very welcome.